Thank you, Mr. Chairman. Appreciate your holding this hearing on the important work of the SEC. And Chairman Gensler, it's great to see you again. And so I want to dive into a component of the Lummis-Gillibrand bill, which you've had a chance to see, that deals with Section 301 of that bill. I agree with statements you and your predecessor, Jay Clayton, have made that initial coin offerings, where digital assets are sold to investors expecting to profit from the seller's efforts, should be considered investment contracts. Senator Gillibrand and I share your concerns about information gaps that can arise when digital assets are later used and traded by others, and the need to ensure users can make informed decisions in the market. So we believe that it is those that raise the money through an initial sale of digital assets and those that continue to provide essential managerial efforts should be held responsible to provide disclosures to the market, and that innocent secondary purchasers of digital assets that may or may not be aware that they're trading in securities should not be subject to strict liability. So in our act, the Responsible Financial Innovation Act, rather than attempting to impose new, complex, difficult to apply rules on secondary purchasers not involved in fundraising transactions, Section 301 of our bill provides for robust technology-neutral disclosure obligations that would hold responsible those who benefited from that fundraising, not the innocent users of digital assets who have no way of knowing what the sponsor is up to. So my question is this: do you have any thoughts on the need for disclosures in the digital asset markets and Section 301 of our bill?
So I thank you for the question. It was good to meet with you and Senator Gillibrand and discuss these as well. I think that the disclosure, as you say, is key. We even recently we're setting up a new industry office to help the disclosure in this field in our corporate finance area. I do think that as you say, the innocent purchaser, let's say the public does not have a disclosure obligation when they buy a stock on the New York Stock Exchange, and it's not the public that should have a disclosure obligation if they buy some crypto security token. But the entrepreneurs, the sponsor, the promoter, the entrepreneurs, that's where the disclosure obligation ought to be. And I think we have authorities now to facilitate and actually have a different set of disclosures, just as we have in other fields. We have different disclosures on something called asset-backed securities than we do for equities. But I do think where I might respectfully differ from, I think, what might be in the question is that I think in the secondary market, 5 years after a stock is issued, a stock of a great U.S. company is issued, there's still a disclosure obligation. And I think that's what Congress did. In 1933, passed a law saying you've got to make a disclosure if you raise money from the public, but the Congress knew that wasn't enough. And in 34, they came back and said, you know what, we also have to cover the secondary market in two ways. Cover the intermediaries, like the stock exchange and the broker-dealers, but also say that there's got to be what's known as periodic reporting, the annual report. Mm-hmm. And so, or maybe there's no difference here, but I think that the investor should not have an obligation. It's the intermediaries, and then it's the common enterprise or the folks in the middle.
And are you thinking that disclosure option or obligation would be similar for initial coin offerings under our bill, or should be under our bill, similar disclosure options as were instituted in 1934?
I think similar in kind, but probably there's some things, it might be a little bit different list. I mean, there might not be a board of directors and things like that. So I really do think your bill had a list. We might differ on that list. We might have other things to put on that list. But it's not necessarily, as you say, everything that a big multinational company is doing.
Okay. Well, I want you to know that Senator Gillibrand and I want to continue to work with you and your staff to make sure that, to the extent that we don't philosophically disagree, that any of those sorts of gaps that you have identified in our bill can be addressed, because I don't see our bill having an avenue to come before this committee or the Congress before the end of the year. But we do intend to have it, to reintroduce it in January. And we want to make sure that between now and January, we've worked with you and your staff to make sure that we can address items that we can mutually agree need to be in the bill.
I look forward to that, and particularly, as I said earlier, in ways that we can ensure we don't undermine the $100 trillion capital market, the definition of security, the definitions of other things that really are under this committee and stay under this committee.
And we've talked about unintended consequences of our bill before with you. We want to address those unintended consequences. Obviously, you see things that maybe we don't because of your perspective. Mr. Chairman, thank you. Really appreciate your being here today, Mr. Chairman.
Thank you,
Senator Lummis. Senator